Vamos gravar agora.
I'll start again. So, first of all, I would like to welcome everyone and thank you, Professor May, for being here with us. It's a huge honor to have you here in our Magister class for my JD seminar at Unisinos. And I'll introduce you in Portuguese. So, Professor May é professor pesquisador e advogado e tem um histórico incrível na sua carreira. Ele é Richard Ryder Distinguished Professor of Law na Universidade de Washburn, na Escola de Direito. Ele fundou o prestigiado Global Environmental Rights Institute na Universidade Widener, na Escola de Direito de Delaware, que se transformou num centro de pesquisa absolutamente referência em nível de direito ambiental, direito climático e também direitos humanos. Ele é professor e lá obteve também a condição de professor emérito na Escola de Direito de Widener e recém-chegado em Washburn, nova universidade que ele passa a trabalhar, lecionando direito ambiental, lecionando direito constitucional e direito climático. Ele tem mais de 20 livros publicados, tem mais de 120 artigos e capítulos de livro, e um dos elementos mais marcantes do professor e da carreira brilhante do professor May é que ele vem participando de ações de projeção internacional em nível de direitos humanos, proteção ambiental e direito constitucional. Ele participou de ações como Juliana versus Estados Unidos, ele participou diretamente em ações como Legare versus Paquistão, ele participou também das ações que envolvem o pós-Katrina, Comer 1 e Comer 2 também. Ele tem uma formação absolutamente transdisciplinar, porque o bacharelado dele foi em engenharia mecânica na Universidade do Kansas, que é para onde ele retorna, a cidade que ele retorna agora em Washburn, e tem desenvolvido uma atividade, foi considerado um dos advogados ambientais mais importantes do mundo por diversas publicações, tendo reconhecimento de Sierra Club, tendo reconhecimento de universidades como Pace, como Widener e como outras instituições. Eu peço a todos que fechem os seus microfones, peço também que fechem suas câmeras para que nós possamos iniciar a nossa palestra. I had this introduction to your resume, my friend, and I presented some of your cases. I was mentioning, Professor May, that you have worked as a scholar and as an advocate in some of the most important climate cases, environmental and fundamental rights cases in the United States and abroad. So it's a huge honor for us to have you here at Unisinos. Thank you so much. As I mentioned before, we are translating this lecture in order to people have access to its content, even though they speak or not English, if they're fluent or not. So welcome, and thank you so much for being here. It's an honor for all of us to have you here.
Well, thank you for that gracious introduction, Dr. and Professor Carvalho. I'm a great admirer of your work and your writings. Boa tarde, everyone. Thank you so much for inviting me to talk with you about climate rights in the United States. Before I get going, Professor Carvalho, if you could just give me a thumbs up that the audio is working okay. We all good? Okay. So I'm going to talk about climate litigation and rights in the US, and it's a complicated picture, partially because the United States has a federal system and a state system, both which have courts, and both that have courts that are construing constitutions. So that's sort of an introduction. So at the end of my remarks, you'll learn about the US constitutional system that's involved in climate litigation. And I will discuss some cases from the federal level and from the state level. And at the end of it, after the end of it, we'll have a conversation, hopefully with questions. One more check-in with Professor Carvalho. Is this pace okay, or would you like me to speed up or slow down?
It's perfect.
Okay, thank you so much. So first, a bit of an outline. Just these things. First, I'll talk a little bit about global climate litigation. That is, what's the extent to which climate cases are being brought across the globe? Second, I'll talk about climate rights litigation in the US in two ways. First is climate litigation involving rights at the national level, so-called federal level, under the US Constitution and under federal common law, it's called. And then at the subnational or state level, under state constitutions and state common law. So that's a basic outline.
Jimmy, I can hear you.
Okay,
We are
how's
not
that?
hearing. Okay, we got it.
Okay, all right. So what you're looking at, if you can see the slides, is just the prevalence of climate litigation around the globe. The darker colors on the screen have more climate litigation, led by the United States. And as you can see, there's a fair amount, in, of course, as you know, in Brazil as well, including some brought by our distinguished host for today's meeting. So here's a snapshot. Around the globe, there have been about 3,000 climate litigation cases that have ever been brought. So roughly in 50 years, around 3,000. About 2/3 are in the United States, a whole variety of cases under common law and statutory law and constitutional law. About 400 are in South America, 300 in Europe, and 300 everywhere else. So again, around the globe, about 3,000, but about 2,000 are in the US. And I'll be talking about a very small portion of those 2,000, which is just cases involving a right to a healthy, stable, or sustainable climate. That is what I call climate rights litigation in the United States. But first, it's important to be reminded of our legal system in the United States. We have federal courts and we have state courts. Federal courts consist of a trial court called a district court, and then cases that are appealed from the district court go to federal courts of appeal. And there are 13 of those across the country. And you have a right of appeal to a court of appeals, but you have to ask the Supreme Court to grant what's called certiorari, that is, to grant permission to hear a case. And the US Supreme Court only hears about 70 70 cases a year. So not that much. At the state court level, likewise, we have trial courts. Typically, they're called trial courts, and then courts of appeal, and then some kind of a Supreme or High Court. So that's just a reminder of how the court systems look in the United States. Now, another reminder is about the role of federal courts versus the role of state courts, because it's different. At the federal level, courts have what's called limited jurisdiction, only the jurisdiction that the Constitution and Congress gives them. Other courts, or only the Supreme Court is established by the Constitution, and other courts, all of them, are established by Congress. There's very limited crossover with state courts. State courts, unlike federal courts, tend to be courts of general jurisdiction. They can hear any kind of a claim, even federal claims. But their existence depends upon the Constitution and the laws of that state. And the state's High Court or Supreme Court has the final word about all questions except for federal constitutional questions. So I'll be talking about two kinds of climate rights causes of action. The first are federal causes of action, and the second is at the state level. At the federal level, there are two kinds of claims to address climate. Some are constitutional claims, and those are brought by citizens against the US government, for example. Example is the Juliana case. The other are federal causes of action in common law. That is typically by states against companies like carbon majors. So we have constitutional cases and common law cases at the federal level, the so-called national level. And what about the state level or the sub-national level? We have the same. We have constitutional cases typically brought by citizens against a state, and we have common law causes of action, also typically brought by states against companies. So before I proceed to talking about the cases themselves, again, let me just check in that we're okay with the audio and the video and the slides. Are we good?
Yes.
Okay, thank you so much. All right, so first, federal constitutional claims. These are claims based upon constitutional provisions in the United States Constitution. Now, let me remind you that our federal Constitution doesn't say anything about the environment. We don't have an Article 225 like Brazil. The Constitution is silent about the environment. It's silent about climate. So how do climate cases get into federal court? Well, they get in through what's known as the Due Process Clause. And the Due Process Clause, as you can see on the screen, it just says that the government can't deprive any person of life, liberty, or property without due process. That's it. It's not a positive right. Can you see how it's a negative right? It forbids the government from depriving persons of life, liberty, or property, but it doesn't guarantee life or liberty or property or anything else. It just says the government can't deprive people of that without due process. So from that due process clause, we get to socioeconomic rights, because otherwise our Constitution is silent about socioeconomic rights. It doesn't have them. It doesn't reflect rights to gender equality or education or the environment or anything like that. But through the Due Process Clause, the US Supreme Court has held that the Due Process Clause protects what are known as fundamental rights. And those are fundamental rights that have been recognized over time in the United States as being fundamental to life and liberty and property. And these include the rights to family, to contraception, to privacy, to same-sex marriage. It's just a handful of rights that the Supreme Court has recognized as being fundamental. The question recently has been whether the Constitution also affords a right to a healthy climate, a stable climate. So that brings me to the next portion of my talk, which is climate rights cases under national, that is constitutional law, that is, under the Due Process Clause. What's happened? Well, the leading case, and just about the only case at the national level, that is the federal level, is a well-renowned case. It's the Juliana case. That's Our Children's Trust versus the United States. And that was filed in 2015. So almost a decade ago, 18 young people filed a lawsuit against the Obama administration regarding its climate policies. And they claim that US policies and practices violated the Due Process Clause of the US Constitution, what I just mentioned. And they claimed that the US Constitution recognizes a fundamental right to a stable climate. And they wanted to get a federal judge to agree. It's not a claim that had ever been brought before. And they found the right judge in the right court. That is Judge Ann Aiken in the U.S. District Court for the Federal District of Oregon. So there are 94 federal trial courts, and they filed in one, and they found a judge who agreed that there is a federal cause of action under the Due Process Clause to address climate change. So that's the district judge found that. Well, the Obama administration fought the case, but the court found that that a climate system capable of sustaining human life is fundamental to a free and ordered society, and that's a fundamental right. That was in 2016. Well, also in 2016, Donald J. Trump was elected president, and they fought this case tooth and nail through the federal system, the Federal Court of Appeals, the U.S. Supreme Court, and 5 years after the case was filed, a federal appellate court called the Ninth Circuit dismissed the case for lack of standing. Now, standing is a doctrine, again, that's, I trust you've heard of it, but it's as bizarre as it seems. It's not in the Constitution, but it's where federal courts, in their gatekeeping role, have said that parties who file lawsuits to be in federal court have to have a stake in the outcome. They have to have a real interest, a real harm involved. And the Ninth Circuit found that the plaintiffs in the Juliana case didn't satisfy the standing requirement because there isn't anything, the Ninth Circuit said, that the Ninth Circuit could do to address their climate injuries. That climate is too big of an issue. It's international, it's global, it's policy-based, and it's political. So therefore, the litigants didn't have standing, found the Ninth Circuit. Well, in the Ninth Circuit, there was one dissenting judge. There is a 3-judge panel, and one of the judges dissented. And this judge was very frustrated with the other 2 judges who found that there wasn't a cause of action. And this judge, Judge Staten, would have held that the plaintiffs had standing, and the case would have allowed the case to proceed. So the Ninth Circuit in 2020 remanded the case back to the district court and instructed it to dismiss. But the court didn't dismiss the case. The judge, the same judge, Judge Aiken, permitted the plaintiffs to amend their complaint to add a different claim for what's called declaratory relief. Again, it sounds kind of silly, but it's a claim asking for a federal judge to rule that the Constitution recognizes a right to a stable climate. And 17 so-called conservative states all across the country asked for permission to intervene. The court ordered the parties to try to settle the case and then denied the interveners permission to join. And granted the request by the plaintiffs to amend the complaint and set the case for trial. It would have been the first federal trial case in the history of the United States on climate change at the federal level. Well, the Biden administration refused to settle the case with the plaintiffs, and it asked the Ninth Circuit, the federal appellate court, to dismiss the case again. Yes, this is the Biden administration asking a federal court to dismiss a climate-based case. And the Ninth Circuit agreed to dismiss the case and subsequently denied the plaintiff's request for what's called a rehearing en banc, that is a rehearing before the entire panel. So next we have climate litigation in federal common law. So I just got done talking about climate litigation involving federal constitutional law, but we also have common law at the federal level. And what we learned here is there is no cause of action for climate at the federal level. The reason for that is one of the cases that the good professor mentioned that I worked on is called American Electric Power versus Connecticut, but it was a state that about 15 years ago brought a lawsuit against electric power companies because of their impact on the climate. So again, 15 years ago. So the question was whether there was a federal common law claim for public nuisance and other common law claims that states could bring. And the U.S. Supreme Court ruled that there isn't. The U.S. Supreme Court ruled that the Clean Air Act displaces federal common law. That is, you can't bring common law claims in federal court for climate. So in the wake of the Juliana case, and in the wake of this case, federal courts are currently closed to climate rights cases and climate common law cases in the United States. Which brings us to the next level, the level under federal, which is subnational, that is state climate litigation in the United States. And much like Brazil, the US is a republic, but it's different. And then every state has a constitution and its own court system that's independent from the federal court system. And much like, however, at the federal level, we have still two kinds of claims: constitutional claims and common law-based claims. And the outcomes are different at the state level than they are at the federal level. So let's have a look. So first, let's look at climate rights cases under state constitutional law, that is subnational constitutional law. In the United States, there are 50 states. Every state has its own constitution. No two constitutions are the same, and no state constitution reads exactly like the federal constitution. So every constitution is different. So let's see what litigants have done trying to enforce state constitutional law to address climate change. Here I'll just use 3 examples. These are state constitutional provisions from 3 states: Montana, Hawaii, and New Mexico. And I'll read this language because it's involved in a series of lawsuits right now that are ongoing. In Montana, the Montana Constitution guarantees all persons are born free and have certain inalienable rights, which include the right to a clean and healthful environment. In Hawaii, the Constitution guarantees that each person has the right to a clean and healthful environment, as defined by laws relating to environmental quality. So Montana and Hawaii have provisions guaranteeing a right to a healthful environment. And then there is New Mexico. New Mexico is a bit different. It doesn't guarantee a right to a clean and healthful environment, but it does guarantee, it does require that the government manage natural resources in a way that does not despoil them. So it prevents the despoilment of natural resources. and that manage those resources for the maximum benefit of the people. So those are three constitutional provisions from just three states that have led to climate-based litigation. So first, I'll discuss the held case. This is against the state of Montana. And here, young people, again, all these cases are brought by youth plaintiffs. Here, the claim was that Montana had violated its own constitution by preventing state agencies from considering climate change in conducting environmental impact analysis. So Montana has a NEPA, an Environmental Policy Act, and it requires agencies to evaluate environmental effects. Well, the Montana legislature enacted a law that prevented those agencies from considering the effects of climate change. So the plaintiffs argued that that violated the state's constitutional right to a clean and healthful environment. So that was in trial court at the state level in Montana. And it was litigated. The trial was about a year ago, a little more than a year ago, June of 2023, 2023, so a year ago. And the trial judge, after that trial, which was a trial that was the first time climate had ever been put on trial in the United States, and after hearing from the youth plaintiffs and court recognized experts, the court found that Montana was violating its own state constitution. So this is the first time ruling in the United States. The court also held that the plaintiffs had standing to bring these claims. First, and second, it found that the state's policies violated the right to a healthful environment. And thirdly, that the right to a healthful environment includes a right to a stable climate. That was also a first-time ruling in the United States. So as a state constitutional provision guaranteeing a right to a healthful environment, the court found that includes climate stability and that the plaintiffs have standing to enforce that constitutional provision. So where's that case now? What's the status of that case? Well, it's on appeal. So the court that made the ruling that I just mentioned is a trial court. So the state of Montana had appealed that ruling all the way to the Supreme Court of Montana. Oral argument was just a couple of weeks ago on July 10th, 2024. So the decision is pending. So we don't know in Montana yet whether the Supreme Court will affirm, that is, uphold the trial court's decision and interpretation of the Montana Constitution. So stay tuned. The second case at the subnational level that I wanted to mention is not as intricate, but it's still noteworthy. And this is the Atencio versus State of New Mexico case. So the New Mexico Constitution doesn't guarantee a right to a healthful environment, but it does say, it does prevent the government from despoiling the air. And it requires the government to protect natural resources for the maximum benefit of the people. So because of that constitutional provision, last year, again, plaintiff, here this time, indigenous groups and environmental organizations argued that the state of New Mexico's oil and gas permitting process violates that state constitutional provision. So, as it turns out, because of shale gas development and other forms of getting more oil and months ago in June, the state district court, that's the state trial court, it denied the state of New Mexico's motion to dismiss the case for failure to state a claim and for lack of standing and other things. So that was a trial court, turned aside the state's objection. The state has appealed that. It asked the trial court to certify that issue for appeal, which it has. And so that issue about whether there's a cause of action under the New Mexico Constitution for climate is on appeal. So stay tuned. The next couple of cases are three cases, are all from Hawaii. Hawaii is the 50th state in the United States. It's the most isolated place on the planet. And it has a constitution that guarantees a right to a healthful environment. And that's been involved in three recent cases. One is involving Hawaii Electric Power and Light. So in this case, the state denied a request by a power company to, in essence, grow trees and burn those trees, thinking, arguing that that was a renewable source of energy and that would help the state meet its net zero carbon emission goals. And the state said, look, that's ridiculous. You're just burning trees. Even if you're replanting them, that's not what we have in mind, and that doesn't guarantee a right to a healthful environment. So the company challenged that finding by the state, but the Supreme Court of Hawaii upheld the state turning aside the power company's request to burn trees. But it's really the language of the decision that's remarkable out of the Hawaii Supreme Court. Language, at least in the United States, we haven't seen before on climate. So this is from 1 year ago. So the Supreme Court of Hawaii said that the issue was whether granting this license in Hawaii was prudent and in the public interest in light of potential hidden and long-term consequences. So there we see the Hawaii Supreme Court using the precautionary principle, in the face of disaster. And the court then held that the right to a clean and healthful environment encompasses the right to a life-sustaining climate system. So again, like the Montana case, the court drew a direct line between a right to a healthy environment and a right to a healthy climate. And then exasperated, the court said, look, yesterday's good enough has become today's unacceptable. And that's underscored in 2024 as well, when we take note that 3 days ago on Monday of this week was the warmest day in recorded human history on the planet Earth, just 2 days ago. And maybe that's been displaced by today again. So the court in Hawaii, for one, is saying, look, we have to do something. The second case out of Hawaii is a case against the government. The prior one was really a case to uphold government authority, but here it was against the government and against the Hawaii Department of Transportation. The long and short of it is that in this case, like in so many, young people got frustrated and are turning to courts for answers. And they argue that the Hawaii Constitution is being violated by the State Department of Transportation. That is the agency in the state of Hawaii that, in essence, decides where highways go and whether there's public transportation, and if there's public transportation, whether it uses fossil fuels, and all of that. So the young people in Hawaii argued that the Department of Transportation had consistently prioritized building highways over other types of less carbon harmful transportation. And in 2024, earlier this year, the trial court in Hawaii set that case for trial. So after the held case last year, the plaintiffs moved forward with a case with the trial court in Hawaii to get a trial. And it looked as though that trial was going to occur. It would be only the second time climate had ever been put on trial. But less than a month ago, on June 21st, the plaintiffs and defendants reached a settlement. So the plaintiffs, Navahin, that's Our Children's Trust, and others, reached a settlement with the State Department of Transportation. And that settlement requires the state to achieve zero emissions in ground transportation by really in about 20 years, by 2045. And it created a climate change council to oversee that transition that would include members of the plaintiffs. So it was the first type of settlement of its kind ever in the United States between a plaintiff and a state government regarding a right to a healthy environment provision to address climate change. So that's state constitutional law. Last but not least is state common law. So what we learned earlier is that there is not federal common law to address climate. What about state common law? In common law, we mean nuisance and trespass and strict liability and fraud and defective products and things like that. To what extent can state common law be used to address climate change? So these are examples that I just mentioned. There are a lot of these cases in the U.S. Currently, somewhere around 30 cases have been filed by state governments and commonwealths. Most recently, Puerto Rico filed a case just a week ago against carbon majors for common law claims. But it also involves actions brought by other states like California and Delaware and elsewhere, and actions brought by municipalities like Chicago and Oakland and Baltimore. So these are common law-based claims brought by state governments against carbon majors like Shell Oil Company, Sunoco, British Petroleum. You get the idea. So there are, as I mentioned, about 30 cases that are working their way through state court systems involving common law. The one I'm going to focus on here is the one brought by the city and county of Honolulu and the Honolulu Water Authority against giant carbon majors like Sunoco is the lead defendant in this case, but it also involves Shell Oil and the other companies that I mentioned, or many of the other companies I mentioned. So about 8 months ago, the Hawaii Supreme Court, this is a case that's been going on for about 5 years. And again, there's too much procedural history to go through here, but you just have to trust me to know that Sunoco and the defendants have been fighting the case tooth and nail. And about last October, 8 or so months ago, the Hawaii Supreme Court rejected Sunoco, the defendant's appeal of the trial court's denial of its motion to dismiss for lack of jurisdiction and for failure to state a claim. So what that means is that the Hawaii Supreme Court allowed the case to go forward, notwithstanding a lot of objections by the defendant carbon majors. So the case got to proceed, found the Hawaii Supreme Court. Well, in February of this year, the defendants, Sunoco and others, they asked the U.S. Supreme Court to get involved. It's really unusual, really remarkable for litigants to ask the U.S. Supreme Court to get involved in a common law case coming from a state. But they asked a constitutional question, that is whether federal law precludes state law claims. So here's the claim. The claim that carbon majors are making is that the Supremacy Clause of the U.S. Constitution precludes states from providing causes of action for climate change. So they're arguing that you can't vindicate climate claims in state courts because the federal constitution would be violated to do so. They also argue that the Federal Clean Air Act preempts state common law causes of action. Preemption means that federal law is so pervasive and so occupies the field of something that there's no room for state law, even state common law. So Sunoco filed what's called a writ of certiorari, asking the U.S. Supreme Court to get involved. And the U.S. Supreme Court has not decided yet whether to get involved. But a little more than a month ago, it did ask the Biden administration, through the U.S. Solicitor General's office, to weigh in to express its views about whether state claims about the climate are somehow preempted or precluded by the federal constitution or the Federal Clean Air Act. So the last bullet point on this slide is the logical consequence of such a finding. It could mean if the Supreme Court grants certiorari and agrees with Sunoco, that would mean that there wouldn't be many places that to litigate climate claims at the state level either. Maybe not any level. Maybe not state constitutional or statutory or common law claims. Maybe they're all precluded. That would mean that there wouldn't be courts that could hear claims at the federal or the state level about climate change. You know, the most pressing concern, faced by humanity now. So that's a recap and an update of climate litigation generally around the world. And the U.S. makes up about 2/3 of it. And then climate rights-based litigation. And there's a lot of climate rights-based litigation in the United States. Some of it has moved the ball forward a little bit, but a lot remains to be seen because the Montana case is on appeal. The Hawaii cases, the case in particular I was mentioning, the Sunoco case, really important cases before the U.S. Supreme Court potentially. The New Mexico case is on appeal, and most other state subnational cases have been dismissed. So that's, again, an update of where we stand with U.S. climate litigation, especially about climate rights. And I hope that that was helpful. Obrigado. So with that, back to you, good professor. Thank you so much.
Thank you so much, Professor May, for this amazing and brilliant lecture. And as I mentioned before, you have a very unique perspective where you blend with a very deep perspective, legal practice with very deep scholar knowledge. So congratulations. I'll get started and I'll mention that everyone can ask questions to Professor May and just put it on our chat. And I'll get started. Can you hear me?
Yes, I can.
Okay. So, Professor May, first of all, congratulations for this brilliant lecture and very clear and very straightforward, but at the same time, deep and wide. I always teach my students, and whenever I deliver a lecture, I try to organize climate litigation, which is not very easy because they are all fragmented and set apart. They're not a coherent body. But okay, we have a first wave of climate litigation in the US and in the world, and I would use that American Electric Power case versus Connecticut as an example, where in these cases, they used, litigators used tort law to address climate issues. There is a second wave, like Massachusetts versus EPA and the Juliana case, where public trust and constitutional issues are more in the core of the debate. We have a third wave that I would say, like Held versus Montana and Hawaii case, which you presented, that are based on state common law and state constitutional law, as you mentioned before. And I wonder if we could mention that there is a fourth wave of climate litigation, where it seems to be growing up again. And these new cases are against corporations, and they are using again tort law, and also using new developments in attribution science. So my question, after describing this evolution of the climate litigation, this very, very raw description that I made, but is tort law back in the game? And will it succeed to its aim to make corporate and companies liable for their emissions? I would like to hear your opinion, and would like to learn about your thoughts about this new wave of climate litigation.
Okay, so thank you for the question. And again, let me just check that my audio is still good. Can you still hear me?
Yes.
Okay,
yes,
fantastic, fantastic. And I think that's a great question. It's twofold. You're asking whether common law is back in the game. The answer is yes. Your second question is it likely to be successful? And I think the jury is still out on that, but so far it hasn't been. So far, common law claims have been brought, and all of the arguments about common law claims have been procedural. That is, for example, whether claims brought by states belong in federal court instead of state courts. The carbon majors would they would prefer to be in federal courts. So they argue when states bring claims in state court that they are claims that should be brought in federal court. And under our system in the United States, state law claims that could have been brought in federal court can be removed to federal court. I'm sorry for the complexity involved, but so if I want to bring a lawsuit against a corporation, and if I could have brought it in either state or federal court, but I choose to bring it in state court, the defendant can have the case removed to federal court. So for most of the state law most of the state cases based on common law, the carbon majors have made that argument. So that takes time, sometimes years, 2 or 3 years, just to answer that question as to which court has jurisdiction. Now, after that, there are all sorts of other questions, like about whether the court has competency, I think is the expression used in Portuguese and Brazilian courts, whether we call it personal jurisdiction, whether the court can exercise jurisdiction over the defendant, whether the defendant has sufficient what are called minimum contacts with the forum state. That's another set of procedural questions. And then there are questions about, on the plaintiff's side, like whether the plaintiffs have standing. So, Professor, this is a long answer, but the point is this. Thus far, common law causes of action, they're certainly back in the game, but we don't know what game it is yet on the merits, because we haven't reached the merits in any of these cases. Like there's no case where there's been a trial with a jury, not to mention a judge, to decide whether carbon majors have committed fraud or nuisance or trespass or deceptive practices, because the cases are working their way through state courts on procedural issues that have not yet been resolved. We've never seen anything like it in the US. The closest is maybe the cigarette cases from about 20 years ago. And then maybe more recently cases involving OxyContin and the Sackler family, Purdue Pharma, but never at this scale or with this many questions. And that makes sense because climate change, it's a local issue, but it's a global issue, and it involves policy and politics and procedure. So these are very, very complicated cases, thus warranting a complicated answer. But thank you so much for the question.
Thank you. Thank you for your answer. And it's interesting how the evolution of climate litigation unfolds, because I spent my last January in New Orleans, and one thing that I learned there was that the one case that you worked on and you were part of it was the Comer case, and I talked to many judges and attorneys there, and they always mention that Comer 1 and Comer 2, although they were not successful in the final decision, they were very influential to the next generation of climate cases post-Katrina in New Orleans and in Louisiana. So it's so interesting how sometimes these cases, they seem to not succeed, but they prepare the basis for the next generation of climate litigation. So your work is a remarkable work in constitutional environmental justice and climate litigation in the US and abroad. We have here with us Carolina Merida. She's professor in UNIRV, University of Rio Verde, and she's a member of our center. She was my JD advisor, and she thanks for your important lecture. Also, Henrique, who is our LLM student, and it's my advisor here at Unisinos, he asks if you understand that climate litigation can be seen as a tool to represent the evolution of climate rights.
What's the question? I'm sorry. Can we try again?
Yeah, sure. Henrique is asking if, in your thoughts, if you think that we could represent climate litigation as a tool that translates the evolution of climate rights and environmental rights into a new dimension. Let me make a set of questions, so I think it would work better if you allow me.
Yes,
also,
go ahead. Thank you.
Angela is our postdoctorate student here at Unisinos and in our center, Environmental Law Center, and she asks if what obstacles that you think avoid climate litigation to succeed, and what strategies would be possible used to overcome those obstacles. And finally, Rafaela, who is also a member of our center, she was our JD student and is a federal judge, and she asks two questions about common law lawsuits. in the face of carbon majors with states and cities as plaintiffs, if you believe that this set of lawsuits could result in an agreement in which carbon majors agree to pay amounts for adaptation measures and loss and damages, and also if you could comment your impressions concerning the Vermont law, the statutory law, which approved a kind of climate super fund, and the places carbon majors are also responsible for paying for these adaptation measures based on some calculations and attribution science. And I'll stop here, and then we get back to some questions later. Did you get all of those?
I'll give it a try. I'm
Okay.
not sure, but and if I miss anything, I'm happy to come back to it. Thank you.
All right.
Those are, just all of those questions are really high level questions. So let me congratulate you and your colleagues for the conversations and the teaching that evidently is paying great dividends with your students. And with the judiciary. So anyway, thank you for all that. So I'll do my best. So here we go. So on the climate litigation as a tool to advance climate rights, if I understand the question, I agree that it is. That yes, that climate litigation is a tool for advancing climate rights. There's no other way. I mean, primarily the way to advance rights is by bringing lawsuits. And that's not just in the United States, but rights-based claims are central to enforcing the Brazilian Constitution, central to enforcing the constitutions of India and Pakistan and Nepal through public interest litigation and so on. I could cite other examples. So, so in some ways, climate rights are the last best hope for people who are affected by climate change. Because we don't have an international agreement that has enforceable limits. We don't have regional agreements that have that. We don't have a carbon market that's international to regulate or manage carbon emissions. I mean, so we're sort of stuck with what's left, and that's rights. So climate litigation can be used to advance rights. Again, as I mentioned before, though, at least in the United States, there's a lot more sound than sensation about climate rights. There's a lot more activity than there is action on the ground. It could be different in Brazil. More on that in a minute. So that's my first response to that question. Délton, should I go on or move on to the next question, or wait for a reply from the person who asked that one?
No, you can move on. Thank you.
Okay. The next one, I think the name is Angela, that I'm not sure, but about obstacles to climate litigation and how to overcome them. There are so many obstacles to climate litigation, especially climate rights litigation. The one being is that at least constitutional litigation in the U.S., it's very hard. It takes a lot of learning and a lot of experience for those who bring climate or constitutional claims of any sort. And then to bring climate claims, you need an additional level of expertise and familiarity with the science. And it's hard to find those people. My background, I just got lucky because my background is in engineering and in human rights law as well. So putting those two together, I'm a decent fit for climate-based cases. Because I'm comfortable with both the science and the law. But it's hard to find people with that kind of a background in this field. Another obstacle is that judges are not very familiar with climate-based cases, because climate rights cases in the United States, just going back to the US, there aren't that many of them. And like the Montana case was one of only it's the first of its kind that was ever brought in Montana. So judges are learning. So there's a steep learning curve, not just for advocates, but for jurists. So that's something to overcome. Another thing to overcome is resources. Um, Human rights lawyers in the United States, they're not paid generally. We don't have a means for being paid to be advocates. It's pro bono. Like all of my work on climate is pro bono. I've never been paid for any of my work on the public interest side. But attorneys and others defending companies and carbon majors, they are paid handsomely. So there's an imbalance of available resources to bring these cases. Another set of obstacles is what I mentioned earlier, is all of these attributes of American law, US law, that keeps the court from getting to the merits. Like the Montana case, the Held versus Montana case, it's the first time in American history, US history, that climate has been put on trial. I mean, literally on trial, where we're hearing from experts about the causes and effects of climate change. And we're hearing from human beings about how climate change affects their lives. That's the first time it's ever happened. So the reason for that is there are all these procedural obstacles to keep parties out of court. And coupled with the imbalance of resources, it's the climate rights-based cases there are very few. You can count them on one hand. And then other obstacles are all over the place, just finding lawyers, finding the right court, litigating cases. People who are advocates understand these kinds of challenges, in addition to everything else that's going on in life. So there are all those obstacles. How to overcome them? I don't know. I mean, the best thing I think in law and in life is to keep trying. If you're knocked down, get up and just keep trying various mechanisms for getting these claims before judges. Again, back to the Juliana case. That was a federal case under the Due Process Clause, the first of its kind. It had never been brought before in the United States. And the plaintiffs, every time they're knocked down, they just keep getting up and keep trying. And in that case, even though the plaintiff's case presently has been dismissed, it's the first time that any federal judge in the United States has ever recognized a constitutional right to a healthy climate. Now, that was reversed on appeal with the Ninth Circuit finding that the plaintiffs didn't have standing, but we had a federal judge make that finding, something that would almost seem to be inconceivable even a decade ago or a decade and a half ago. So it takes imagination and innovation and a lot of energy and a lot of persistence. Just keep trying whatever claims can be brought in whatever court can hear them, to hope that you can find a judge like Judge Aiken, um, uh, or Judge Sully in Montana, um, or Justice Wilson or Edens in Hawaii. It just takes really one judge to recognize the claim, at least in the U.S. system. Which brings me to Brazil. So I'm not an expert in Brazilian law, including climate law, but I have written about it. Luciana Bauer and Professor Marcelo Busgallo Dantas and I wrote an article that we just published a couple of months ago, comparing climate rights cases in the United States and Brazil. And getting back to what to do to overcome obstacles, is to focus on the differences in our systems. Like the US at the federal or state level does not have a minister publico, a public minister that has authority to enforce human rights and to bring claims, including for damages. We don't have anything like that. So that's a difference to continue to discuss. So potentially, the public ministers in Brazil have more authority and more leeway, more capacity to hold carbon majors accountable than litigants do in the United States. Also, litigants and advocates, again, like your good professor here, have been leading the way on trying to vindicate public interest to address climate change. And there are some obstacles in the United States that don't exist in Brazil, like the standing doctrine doesn't exist the same way anyway in Brazil. So in that way, arguably, it's an easier path, not easy, but an easier path to bring a climate claim in Brazil. Now that said, there are many more cases in the Brazilian judicial system than there are in the U.S. system. I mean, certainly at the high court level. Like I said, the U.S. Supreme Court only hears about 70 cases a year, and in the Brazilian Supreme Court hears many times that. So that means that it might take longer to litigate a case in Brazil, or there might be other ways that the case never sees the light of day, where it might in the U.S. because there aren't as many cases. So overall, so those are just some thoughts about what the obstacles are and overcoming them. That's the second question. The third one, oh, let me just check in. Délton, are we still good on audio here and video?
Yes, we are.
Okay. All right. The third one is about common law. Rafaela, I'm not really sure on the name, but what to, the common law claims, are they the future? Kind of gets back to Professor Carvalho's question as well. So yeah, so common law currently, given that the Constitution at the federal level doesn't provide a cause of action, that federal common law doesn't provide a cause of action, we're left with state common law, which is where most common law in the United States is. So there's a tort action in the US, it's brought under state law. There's a property action, it's state law. Contracts, state law. Criminal law, state law. That's all state law. So there's a lot of jurisprudence and a lot of applications for common law. And in particular, though, this case out of Hawaii, the Sunoco case, if the Supreme Court grants certiorari, agrees to hear the case, and that's a big if, it only grants certiorari on less than 1% of all cases that where parties have applied for Supreme Court review. So it's really rare to get a case before the Supreme Court. But if the court grants the carbon majors request to hear that case, and if the court agrees with the carbon majors, it could mean that states can't do the sort of thing that Vermont has done. And again, that's a great question about this recent development. For those who aren't familiar, the state of Vermont has developed a law that, much like the what's called the Superfund law in the United States, but it holds parties that are responsible for climate harm jointly and severally liable for the effects of climate change in Vermont, in the state of Vermont. And it allows the state of Vermont to recover money to pay for the adverse effects of climate change. In essence, to pay for mitigation and relocation. So it develops a fund. Again, at the federal level, we don't have a fund for climate. There isn't. No state has a fund for climate. Vermont is the first state to develop a law that would create that kind of fund that would be collected from those who are responsible. But again, getting back to the Hawaii case, the Sunoco case, if the Supreme Court grants certiorari on that case, it could potentially decide that any state laws conflict with either the federal Constitution or the Federal Clean Air Act and are therefore either precluded or preempted under federal law. So again, that's likely to be, there's likely to be legal challenges to the Vermont law on that ground. There's also an argument that the Vermont law violates another aspect of the federal Constitution of the United States, which is called the Dormant Commerce Clause, which prevents states from somehow favoring businesses in their own state. So there's some argument that the Vermont climate law will favor local businesses over out-of-state businesses and carbon majors. So again, that remains to be seen. I don't know when that would be litigated or when it would be resolved, but given the United States, everything is litigated. My guess would be that would be too. Again, so those are the three groups of questions. I hope I've covered what was asked, but if not, please let me know and we'll fix it.
Yes, you did. You did, Professor May. And I'm glad that you mentioned the article you co-authored with Marcelo Busaglu Dantas and with Luciana Bauer. I strongly recommend and suggest for the audience to read this piece. It's entitled Climate Rights in Brazil and the United States, a Convergence in Contrasts. And it was published, would you help me, Professor May? It was published in Washburn, was it?
No, it's published in the Case Western
Reserve.
Law, Case Western Reserve Journal of International Law, and it was published about I don't know, maybe a month and a half ago. So yeah, it's fresh and it's out there.
Yeah, and it's a very interesting, deep, and important piece comparing these, and it's very rare to have these articles comparing two traditions of legal system. And Professor Marcelo Busaglu Dantas is a very well-known scholar, environmental law scholar and litigator in Brazil. It's a friend of mine, and it's an amazing colleague. Likewise, Luciana Bauer is a JD student in the US, and it's a former federal judge who is also doing a great work in climate law. So I strongly recommend the reading of this text and article, and we are working with this text in our JD, with our JD students. So the last two questions, they come from Robinson Miranda. He is a PhD student in international environmental law at Unisantos, São Paulo, and he asks, thank you for the lecture, very enlightening. My question is, do you understand that climate litigation can be considered a tool of environmental governance to the extent that it expands the possibility of participation of new non-state actors in issues related to fundamental rights related to environment? So this is a Robinson question, and I welcome him. And also we have a very interesting question from Gabriel. He is a physical education student, Gabriel Rampon, and he asks, do you think that catastrophes affecting the United States have any human influence? And furthermore, what can the population of Rio Grande do Sul learn from Americans when it comes to preventing climate disasters? So this is a very interesting question. And thank you, Gabriel, and thank you, Robinson, for your questions and for attending our lecture. Professor May.
Yes. So Professor, what was the first part of Gabriel's question? Something about catastrophize.
Yeah.
I didn't catch it. Sorry.
Yeah. Do you understand that? Let me find here. Sorry. Do you think that catastrophes affecting the United States have any human cause? This is the first part.
Okay. Okay.
It's a hard
Gotcha.
one, right?
Okay. All right. Taking Robinson's question first. Yes, I agree that climate litigation is a tool for environmental governance. It's not a traditional tool. The traditional tools about environmental matters that are um, international, that cross borders, that affect the whole world, like climate change, have been multilateral environmental agreements, like the Montreal Protocol on to protect the stratospheric ozone layer, the UN Convention on Law of the Seas, the Basel Convention, the Bamako Convention. I could go on and on. Of course, and the Rio Declaration. What am I saying? Brazil has been so important um, in the advancement of those multilateral environmental agreements. The SDGs, of course. So, so private litigation is an unconventional way of addressing international problems. But given that we don't have, again, an international agreement with enforceable limits, the Paris Accord doesn't have enforceable limits in it, and we're 10 years on now from the Paris Accord, and that was supposed to be, so pioneering. So climate rights litigation, private litigation fills the gap. It fills the need to make progress somehow, somewhere. If we had an international agreement, imagine what the world would be like. First of all, we wouldn't be at 425 parts per million of carbon, most likely. And second of all, we wouldn't be having this conversation, most likely, about climate rights, because we wouldn't need to. There isn't, for example, stratospheric ozone-based rights cases all across the globe, because there's an international agreement that manages production and consumption and so on of ozone depleting gases. We don't have that for carbon. So we turn to other mechanisms to try to address and redress the problem. The challenge part of it as well that private rights has, that's different than international law, is the role of democracy. Are private causes of action democratic? There's been a lot of writing about that lately. I tend to be in favor of of of, uh, of opening courts and judges to hear human rights-based claims, especially in the face of the tyranny of the majority, for example. However, when judges render opinions as a follow-up to private rights cases affecting, a few people or a population or even a community, is that democratic? Because then you have a few people, like in the Held case, it's 11 youth plaintiffs testified at trial, and it's turning around climate policies, or potentially turning around climate policies in a giant state of the United States. And that's not because of a political referendum. That's not because of an act of legislation. It's because of a private cause of action. And so again, that raises anti-majoritarian questions, because rights-based claims are anti-majoritarian. So that's an open question, is how to reconcile that. Democracy generally is viewed um, as a societal good. Generally is viewed as a good, but when there are parties that bring actions that only are brought by a few people, and not and don't have the benefit of a full democratic vote or what have you, it raises these kinds of democratic tensions. So that's one thing. That's also partially answers a question I received earlier about obstacles to climate rights-based cases. Arguably they're anti-democratic. Okay, so those are my thoughts about Robinson's question. So Gabrielle, the question about catastrophes. Yeah, I think there's wide acceptance at this point in the United States that catastrophes are many of them are caused by climate change that's been induced, if not caused by human beings. So in the United States, again, it isn't only the US, it's all around the globe, but we're experiencing heat events like never before, drought like never before, wildfires like never before, forest fires like never before, and so on and so forth. And so I think there's general acceptance that that the burning of fossil fuels over the industrial age of the last 200 years or so is largely responsible for these catastrophic effects. And they're only going to get worse, right? They're only going to get more pronounced as the planet continues to warm and warm faster and more greatly than even the most dire predictions had it at 10 years ago. 2024 will be the warmest year on record. As long as human beings have been recorded history, it'll be the warmest year. Next year will be warmer. The year after that will be warmer. So what to do about that? Keep getting up. The second part of Gabrielle's question is, what's the way I heard it anyway, is what there is to learn from America, from the United States, if I understood that question correctly. And I'm sorry to say, there's a lot to learn, but none of it's good. You know? The debate about climate change has been very divisive. In the U.S., it also has, there are economic issues because so much coal and oil and gas is produced in the United States. The United States, over the last 2 years, 3 years, I forget, has been the largest producer of oil and gas in the world again. So that's not consistent with trying to address climate change. But on the other hand, there is progress at the federal level. The Biden administration passed, with Congress, passed the most ambitious climate legislation in U.S. history and arguably in the world. It has a weird name to it that's called the Inflation Reduction Act, but it puts money behind renewable energy is the bottom line of what it does, and money behind climate mitigation. So it doesn't regulate greenhouse gases, but it promotes and subsidizes alternatives to burning fossil fuel. So that will take time to catch up. But while that's happening, there are other things that are happening to offset the gains that have been made over the last 5 years. For example, private jet travel, travel in private jets has increased by 5 times. It started with the pandemic when more people started flying on private jets, and now it's just become much more common. And private jets on a per person basis put out 10 times the amount of carbon as do commercial jets. So, that's just, again, there are all these obstacles and things in the way of making progress on climate. I do believe that there's a role of the rule of law. I'm still hoping sometime before I leave this planet that there will be a multinational environmental agreement that has enforceable limits on carbon. So that's what I'm still hoping for, because I think that's the best way to do the most good for the most people on the planet. But along the way, we do what we can with these other mechanisms. So again, I hope I answered those questions as well. I really appreciate that.
Yes, you did, Professor May, and I hope so too. We have one more question, if you don't mind answering. Caroline is our JD student, and I'm her advisor at Unisinos, and she asks about environmental and climate governance. If you think that in the US, the levels of governance are effective to address climate change, And besides that, taking into consideration the global governance or the multi-level governance, what are your thoughts about strategies, governance strategies, in order to deal with this global issue that you have to address locally? So I'm not sure if I was clear, but let me know if not.
Okay, well, I'll give it a shot. Thank you, Caverghini. I'm sorry if I messed that up. Again, really interesting questions. These have all been just terrific questions, and this question goes to kind of how to get the job done. You know, what kind of global governance mechanisms can be used, and my talk did not involve what was happening at the global level, at the international level, but there are things happening. You know, like the International Court of Justice will soon be issuing an advisory opinion about the obligations of current generations toward future generations for climate change. So that's the ICJ. And then there are petitions under consideration before regional entities. The one that comes to mind, also about climate change, is for the Inter-American Commission on Human Rights, or Court of Human Rights, also asking for an advisory opinion roughly for the same reasons as the ICJ advisory opinion. The United Nations General Assembly 2 years ago recognized the right to a healthy environment, and 3 years ago the United Nations Human Rights Council did the same thing. The European Council is considering that kind of a mechanism for addressing a right to a healthy climate, and the relevance of those findings or those developments is much like held in Hawaii in the two cases from the United States, where the courts found that the right to a healthy climate incorporates, a right to a healthy environment incorporates a right to a healthy climate implicitly. So as we have developments about environmental human rights, that arguably covers climate rights as well. Here's my take about all this. As I mentioned earlier, I would favor an international multilateral agreement about carbon emissions, you know, with enforceable limits and a dispute mechanism, and provisions for technology transfer, and also for reparations, you know, to pay countries that were the least responsible for climate change, but the most affected by it, for relocation or mitigation or compensation. So I would favor that if we can ever get to that point. And then short of that is to pursue regional agreements to address climate before one of the half dozen region, or under one of the half dozen regional entities that do so. You know, again, beginning with the Inter-American Commission and Court on Human Rights, but also the others, including the European, under the European Convention on Human Rights, the African Convention on Peoples and Human Rights, and so on. So that's the regional approach. And then I think the least efficient generally is going country by country to bring lawsuits to address climate. Now, again, that's sort of all we have at the moment because we don't have an international agreement, but perhaps there is more progress that can be made. And this is, again, where I think Brazil can be a game changer. And I'm still waiting for somebody to tell me that that's wrong, if that's wrong. But because it has a unique feature under law that at least I'm not familiar exists the same way anywhere, and that is this, you know, again, the authority that Ministério Públicos have to protect and enforce constitutional rights, including by seeking damages. So my understanding is that public ministers can bring lawsuits against carbon majors for violating the Brazilian Constitution, including Article 225, and including for damages. So I see that as kind of a legal route that is unique and could make a difference as well. So again, I really appreciate the question. I think it's, you know, super interesting. At this point in time with the climate emergency, I just think, you know, we try everything and anything to promote fairness and outcomes and mitigation and compensation and responsibility for the Anthropocene.
Professor May, I need to thank you so much for this brilliant lecture and this Q&A, very productive and prolific. Thank you so much for being here. I would like to thank as well our IT department at Unisinos and ASAV. Thank you so much for making this possible. I would also like to thank the translators, Ramiro and Marcia, thank you so much, and our center, which we call Research Group here in Brazil, that I'm the coordinator and director in environmental law, climate law, and disaster law. And it's called Law, Risk, and Ecocomplexidade, in Portuguese, Direito, Risco, e Ecocomplexidade. I would like to thank all the members that made this magister class possible. And we had almost 100 people here during your talk, Professor May. Exactly, we had 93 people here. So for this type of subject, which is a very specific one, but due to your brilliant career and all the work you have done so far and your background, all these people came to attend to your lecture. Thank you so much once again. I hope we can have you here in person soon. And we keep reading your work and being inspired by it. Thank you so much, Professor May.
Obrigado. Obrigado, Professor, and everyone. I hope you have a wonderful day and stay in touch.
All right. Bye-bye, everyone. Thank you so much for being here, attending this lecture and this magister class of our JD program. Bye-bye.